So we'll just kind of start with an overview of who we are and what we're responsible for as patients' rights advocates. So California law requires every county to appoint at least one patients' rights advocate. We refer to ourselves as PRA for short. Marin County BHRS contracts with Mental Health Association of Alameda County. That's our association that we work for to provide these mandated services in Marin County. Mohawk is what we refer to ourselves, also provides PRA services in Alameda, San Mateo, and Sonoma counties. So it's really nice to have the other counties to kind of bounce things off of. Every county does something a little bit differently. We do some things the same. So it's really nice to have everybody to kind of talk to about different issues and how this county does one thing. And yeah. And so here in Marin, Andrea is the main advocate, and then I am technically her supervisor, but she's the main appointed advocate for the county.
And then this is just not super relevant to patients' rights, but it's just our agency's mission statement, just kind of covering what we do. It's to empower adults and youth with mental health conditions and their families to live their best lives, doing it through education, support, advocacy, shared experience. We provide client and family-driven services delivered by highly trained, compassionate, and committed staff who share the belief that recovery can and does occur. So our agency is not just patients' rights advocates. We have like some family programs in Alameda County. Most of it's through Alameda County, but patients' rights is the one that we work for. And we basically serve mostly inpatient consumers. So we spend a lot of time in inpatient facilities, block facilities. We can also and do work with outpatient clients, family members, providers such as yourselves. Basically for Marin, anybody who is receiving mental health services in the county gets our services. There's no charge, no insurance, no nothing like that. And our general programs serve over 24,000 people every year as well.
Kind of our rule of thumb is even if it's not, our responsibility, we'll still try to find resources or, the right phone number of, whatever the person calling, whatever their question is. Maybe it's not a patient's rights issue, but maybe it's, how to get in touch with like bridge services. Okay, like let me figure out, here's the phone number for them, that kind of thing. So we always try to at least start the process of getting them, pointed in the right direction kind of thing.
This is a lot of words here, but this just kind of covers our basic duties as advocates. Our main job is to promote and represent mental health consumers' rights and their expressed interests. And that essentially means that we represent the client's interests as defined by the client. So most providers work on the client's best interest and have some kind of input into what's best for them. We just work solely on essentially what they want, if that makes sense. Did you want to talk about that one at all?
Yeah, just that, we of course are invested in what's best for the client, but it is our job to listen to what they're expressing their interests are, and we are not clinicians, and so we're depending on the clinicians to decide what's best for them, and we're just here to kind of listen to them and make sure that their rights are being upheld and that somebody is listening to what they want. Whether that's the best thing for them or not is not our decision to make, but just to listen to them.
And the main kind of things we do are complaints, investigation, resolution. We do education and consultation, such as this, monitoring of facilities, just kind of going around and checking how they're doing, seeing if they're following statutory duties. And then a small part is hearing representation. That's a lot of like involuntary holds and medication hearings for involuntary medication. It's mostly what we do. Okay, that's kind of our overview of PRA services, and now we're going to kind of get more into like things that are more relevant for this setting, residents' rights, and can you mayor So this happens in a lot of different times, so it should be happening on a regular basis, but there are certain requirements for like when they actually have to be informed of their rights. So when a patient is first admitted to a facility, they usually get like a little sheet of like patient's rights or residents' rights that they get. And then there's also a requirement for the posters that are, I think, over by the nursing station here in the hallway, or by the phones. Yeah, so those have to be there. If they get ripped down, we can help you get access to them. The state doesn't let us order them anymore, but we can help you guys fill out the form. And then education from like me towards residents, staff, anybody who wants it, and then like Tashi and like some other databases.
Yeah, and also, you know, if you guys have specific questions, we're, you know, always available for phone calls, emails, anything like that. We're always around, Andrea especially, but of course myself as well.
Okay, so now we're going to talk a little bit about denial of rights. So essentially rights, there are certain rights, you know, on the poster and other rights that are available to clients that can only be denied under certain conditions. The first one is upon failure of all other means taken to resolve the behavior or the issue. If good cause exists, and then if the reason for denying the right is a clear relationship to the specific right being denied. It's kind of clunky legal language.
Yeah. I mean, so an example of a deniable right, a simple one, is the right to receive and make phone calls. And so if you're going to deny that right to a resident, there needs to be a clear reason that relates to them receiving or making phone calls. Maybe every time they call their mom, they get really agitated and upset and start slamming, you know, the receiver of the phone and, you know, threatening to hurt people. I don't know, that's pretty extreme, but something like that. It would need to be, you need to have good cause that's related to the actual denying the right of the phone. It couldn't be like they were throwing food, you know, in the dining hall, so now we're gonna deny their right to phone calls. That's not related. So that's kind of a breakdown of the clunky wording there of what that actually means.
I have a question about that. So if a client is, every time they get on the phone, they're calling 911, we can deny the right to use the phone? Especially if we know they're not calling anyone else? Because that happens where there's no one else they're calling.
If that
It's
is
just
happening
911.
repeatedly.
Oh, yeah.
You can. And Andrea will both get into it in some of the upcoming slides, but basically they also need to be able to earn that right back, and so there needs to be regular check-ins of like, okay, we need to be able to.
It's usually temporary, you know, like for the rest of the shift or the afternoon.
Oh, yeah.
Yeah,
definitely.
not like on permanent.
Yeah, and that's the main thing, is that they're able to earn it back. So yeah, maybe they lose that right for the rest of the day, and then the next day they get kind of a clean slate, let's try again.
I'm just gonna put all these words up here. Okay, sorry about all the transitions. Okay, so this is more kind of about denial of rights. So the can be denied as a condition of admission, a privilege to be earned, punishment, convenience to staff, or as part of like a treatment program. So this is what like we hear a lot of the times from facilities is like, well, it's part of their treatment plan. It's like that doesn't fall into the denial of rights conditions. There has to be more of a specific event-based situation to deny certain rights. And it can only be, this is a very finicky part, but the actual denial of the rights, excuse me, can only be ordered by the person authorized by law or regulation to do so. So like, for example, like a mental health technician wouldn't fall under this authorization. It would have to be, I believe, a physician or the owner of the facility who can actually order the actual denial. And then this one's really important for Canyon Manor as well, is that unless specifically authorized by a court order, a resident's parent, guardian, or conservator cannot waive their rights. That's something that facilities kind of sometimes forget is that like if a conservator says they can deny the right, that they cannot unless there's some sort of like court order authorizing that. It has to be ordered by the person who's authorized by law.
Yeah, exactly. And again, it can't be used as a punishment or a convenience or anything like that. And I think, you know, the actual denial, it really needs to follow a specific, you know, succinct kind of situation, and it needs to be by the doctor or the person who owns the facility. And I think there's a lot of confusion in that and how it's documented. It's like, oh, well, you know, the social worker saw them, you know, banging the phone on this, and so the social worker wrote up that they are denied from the phone for the rest of the day. It's like, I get that it's the social worker that saw it and that kind of thing, but they can't actually order the denial of rights. They can let the physician know, they can let you know, the owner of the facility know, and they can write up the denial of rights. And then Andrew will get into what kind of happens after that, but that's the only way that it kind of gets triggered into an actual denial of rights.
Any questions? Good to move on? Sorry about my voice going up here. Okay. I'm just gonna put all these on the screen. So, this is more about when actual good cause exists. So the first thing is that exercising the specific right would be injurious to the resident or patient. So like that would be denying the right to wear their own clothing with a belt if they are trying to self-harm with the belt, for example. That would be injurious to the resident. Two is infringement. So that a specific right would seriously infringe on the rights of others if exercised. That's usually the 911 example. So it's like if they are calling 911 a lot, that sort of infringes on the rights of other folks to access 911 and emergency services. That's where you can deny the right. Damage, so the facility would suffer serious damage, like physical damage, if a specific right is not denied. I haven't had a good example of that one.
If you were to actually break the phone,
Right.
you know, but that's pretty rare. But
Yeah.
the thing that's so hard, they're in danger of actually breaking the phone.
So one of those three at least has to be present, and then there is no less restrictive way of protecting the interests in 1, 2, or 3 also has to exist. So it's, you know, if you've already tried telling the client like you can't use the phone, or trying to say, well, have nursing call the number for you and then we'll get you on the phone, if you've already tried all the less restrictive measures and hasn't worked and they're still calling 911, you can deny the right. You don't have to answer this question. So we're going to talk about undeniable rights now. This is going to be a whole lot of text. We'll go through the first couple ones. So there's undeniable rights. Treatment which promotes the potential of the person to function independently. That's undeniable. Treatment that's provided in ways that's least restrictive of one's personal liberty. One that we say all the time is dignity, privacy, and humane care. That's a really important one.
Yeah, a good example of that is just, you know, making sure when you're talking about residents that, you know, that you're closing the door, if you're speaking about them so that they don't accidentally walk by and hear their name and go, oh my gosh, why are they talking about me? Or that another resident walks by and goes, oh, they were talking about John Smith. Like, you know, that's definitely an invasion of their right to privacy, and also their dignity, because maybe you were saying something that's maybe not super kind about that person. So to just make sure that you're keeping that private and keeping their dignity intact.
There's also the right to be free from harm, including unnecessary or excessive physical restraint, isolation, medication abuse, or neglect. It's pretty simple. Another undeniable right is that medication cannot be used as punishment for the convenience of staff, as a substitute for a program. That's just the language from the law, or in quantities that interfere with the treatment program. That's that one doesn't come up as much in like facilities like this, but
Yeah, it's usually more in kind of the acute care setting that, you know, if somebody's really getting out of hand, you can't just medicate them to kind of like take them out for the rest of the day so it's convenient for everybody else. Doesn't mean that you can't give emergent medication, it just means it can't be, you know, excessive just to like make it so they're not a problem for the rest of the day.
The right to prompt medical care and treatment, the right to religious freedom and practice, the right to participate in appropriate programs of publicly supported education, the right to social interaction, participation in community activities, physical exercise and recreational opportunities, which are plentiful here, which is wonderful, to be free from hazardous procedures, receive the services of a PRA, and refuse psychosurgery, and then refuse ECT except for in some specific circumstances of law. So these are all the ones that are undeniable and remain as rights for the residents, regardless of if there's like some sort of wish to deny them that right.
And these are all on our posters that are on the walls. So they're up around, I know, again, it's a lot of words, but if there's specific ones you can't quite remember, they're all on the posters.
Okay, we're almost, I think we're halfway done. Okay, so then we're gonna talk a little bit about the medication. So residents have the right to refuse medication except in an emergency as defined by law, and then when a judicial ruling has been made that they lack capacity. This is a lot of the time what is the case for those conserved or LPS clients that you guys have. A lot of the time, their case, the judge has ruled that they lack capacity, and therefore the conservator might have responsibility for doing informed consent. Some counties do that automatically whenever they put clients on conservatorship. Some of them actually have the judges review it. So it just kind of depends on the person, but that's pretty common here. And residents can't be persuaded or threatened to accept medication, can offer medications by IM without offering oral dosage if a resident requests it is administered by IM. It's just a point that we put in there from before.
But typically you would offer it orally first before going to IM on this. There are people who prefer IM sometimes, like maybe they have trouble swallowing or something like that. But typically it's offer it orally first, and IM is usually only used in emergencies.
Okay, now we're going to get into that part about what's the actual procedure for denying a right. So the first thing to do is figure out what is the good cause. Back to that list of 4 things of injury, infringement, physical damage, and then if less restrictive measures don't exist. Then figure out what the good cause is and then document that reason. When did it occur? Document the date and time of the actual denial. So if we told Tashi to get off the phone at 3 o'clock and say, you know, on the record, you know, at 3 o'clock, we denied Tashi the right to use the phone because she was hitting it on the receiver and was going to break the phone, for example. Check if the doctor or the administrator ordered the right to be denied. Again, that gets back to if the person in charge of the facility or the physician actually made the order. Then was the resident informed? They have to be informed at the time it's denied, so they have to be told what the contents of the order are to deny them that actual right. Say, you know, we're not letting you use the phone because the doctor ordered it to be denied because it is causing damage to the facility, for example. That would be a fine way to do it. And then as the day goes or the shift goes, continually assessing, and then restoring the right at the earliest time possible. So as soon as it's possible to restore them that right, as soon as the dangerousness no longer exists, it gets restored back to them. Any questions on denial of rights? Cool? Okay. Keep moving. This is kind of our PRA procedure about complaints. So, whenever we receive a complaint, our approach is to first gather information, investigate the complaint, and then collaborate with facilities on those solutions. Clients, I'm sure you all know, have a lot of concerns about things, and they'll make a complaint, and sometimes it actually goes into a real actual investigation. A lot of the time it doesn't, but we want to just kind of first gather information, look at the situation, and then collaborate on a positive solution. And then we all have the exact same goal, is ensuring that residents receive quality treatment that's in compliant with necessary codes and regulations. That's our main goal when it comes to complaints that we get from clients.
Yeah, and it usually won't go to a full-on investigation unless we feel like their right might actually, their rights are actually being denied, without the right documentation or something like that. If it's not really a patient's rights issue, it doesn't usually go much further. We may, let the facility know, hey, so-and-so had this complaint, they complained that, there's not enough snacks at snack time or something, or they're not getting snacks often enough. Not necessarily a patient's rights issue, but something we may let the facility know, just so you guys know, or, there's not enough snacks with protein or something like that. But unless it's actually a patient's rights issue, we don't usually go into like a full investigation.
And then, so this is clarification on one of the parts of the codes that says there's immunity for complaints. So there's immunities for anyone participating in filing a complaint with patients' rights, and then immunity for anyone providing information related to complaints and investigations. And there's also protections against any kind of retaliation. So facilities can't discriminate or retaliate against residents or employees for participating in complaint processes. And then all residents and employees are protected by law to exercise their right to file complaints with us. It's just a reminder of the protections. So if there's any concerns about patients' rights brought to us from them or from any of you guys, there's some safety protections in place. Next, we're going to talk a little bit more about conservatorship. Obviously, most of the residents here, I think, how many of your residents are LPS? Majority? Two-thirds. So most of them have a conservator, and there's some differences for conservative clients, kind of in terms of some of their rights. We were talking about this earlier, about kind of the responsibilities of a conservator in general, and they have kind of a lot of responsibilities. The main kind of condensing it down into these ones are that they are a court-appointed decision maker. They determine an appropriate level of care for clients. They act on behalf of the person a lot of the time in decision making. They assure that needed treatment is provided to the client. They're supposed to monitor treatment plans, and the kind of big goal is that they're there to protect the conservatee and their personal assets. So these are kind of their general responsibilities. It gets more kind of nitty-gritty when we get into the details, but that's mostly what they're there for.
These are the main things that residents will ask about too, is kind of like, what's my conservator responsible for? And these are kind of the ones that they're mainly concerned about, that this person is going to determine where they live, those types of things. So again, these aren't all their responsibilities, but these are kind of the big ones.
And then basically when clients are conservators can recommend for or against the imposition of certain disabilities on a proposed conservatee, and then usually the court designates ones that can and cannot be imposed. As I said earlier, some counties just have like a very automatic system of how they do it. Certain rights they automatically restrict. Some counties are more reliant on the judge to make those decisions specifically about all of the rights, but these are kind of the possible ones that conservators can recommend for or against. The first one is the driver's license issue, possessing a license and operating a motor vehicle. That comes up in my patient's rights group all the time. Possession of firearms, voting. This one is not automatic. It used to be automatic quite a long time ago that it was taken away, but it's no longer automatic and it can be given back if it's taken away. Consent to treatment. This is the issue of capacity that we talked about earlier, and that's treatment related specifically to the conservatees being gravely disabled. That basically means psychiatric treatment. Consent to medical treatment, which is like routine medical treatment unrelated to grave disability. That might be, like a broken arm or something.
Some kind of surgery.
Yeah, or maybe even like root canals or something like that.
Yeah, because sometimes people aren't taking care of their medical needs, and so something conservator does need to step in
And the last one would be contracts, so specific types of transactions or transactions over a certain dollar amount that might be restricted from the client and given to the consumer. That's mostly what we had for you guys. And then we're gonna send this to Tasha, but this is kind of our main contact phone number, our email. If you guys ever want to contact one of us directly, you're more than welcome to, but we like to give the program contact because one of us may not be in office or we might not be available. That's our website for our agency. And then I also included the link to the state's Patients' Rights Handbook and the posters that are given out. Like I said, you guys can order them directly from the state, they're free. There's just like a form that you have to fill out if you need them. And then the only issue is that it doesn't include our contact info on there. So if you guys do order them, we have like stickers that we can put on them and we can help put those on. It's a tedious task. But if you guys need more, that's kind of where you get them. And I'll send Tasha the presentation.
And if you guys ever have questions, if we're not in office, there's always somebody who is. So even if it's the weekend, late at night, believe it or not, we do have people that they may not answer the phone right when you call, but they will get back to you in a timely manner. So don't be worried like, oh, it's a Sunday, nobody's gonna pick up my call, I'll just wait till Monday. No, reach out to us at any time.
I don't know how long our time window is, but if anybody has any other topics or if you have more time,
Yeah.
I'll hang out.
Does the patient have a right to police report support?
That's
In what way?
charges?
I think you recently had an incident anyway.
Pressing charges,
Like where if they're allegedly
assaulted. Yeah. If a client's assaulted, do they have the right to press charges?
Go ahead.
Is it something that happened here? Like, is it they're alleging a crime
Yeah.
occurred here?
And there's witnesses, like it happened, okay, and they want to press charges.
I would say so.
Yeah, I think so.
And when the police deny that, what do staff do?
Let us know. Let us know. That is
What term?